एक सेकंड
Just one minute.
हमने देख लिया है. आप will you be assisting कुर्ता साहब? Yes, will you be assisting or not? Yes, we can't compel in amicus.
Sir, would you be assisting the honorable court?
Yes, sir. If as
No, because that's enough. Is Mr. Tariq Mahmood present?
No, I think he's not well. He's excused himself.
So, and during the course of proceedings,
Kazuri sahab, aap tashreef rakhein.
on the objection,
Let's
Mr. Kasuri had excused.
Mr. Khalid Anwar, is he present?
He also excused himself.
He is?
He excused himself. There's an order of the court on this issue.
Okay, and Mr. Makhdoom Ali Khan?
He's never excused himself. He's not here today.
Not here. Okay, 1 second. So,
And then Mr.
okay, now we are left with who all? Mr. Ihtizaz Ahsan, where is he?
Present on behalf of Mr. Makhdoom Ali Khan. I'm present here on behalf of Mr. Makhdoom Ali Khan. He wasn't sure if your lordship will be issuing fresh notices to the amicus because, as noted by your lordship, many of them have passed away.
Bhai, सीधा बात करें ना. Just tell us about Mr. Makhdoom Ali Khan. Don't
My
make a
lord, if
speech.
your lordship so desire, he will be present.
It's not our desire. He has been appointed amicus. Try to understand the matter.
My lord,
we cannot compel an amicus. Will he act as amicus or not?
He will be present, my lord.
He will act as amicus.
Yes, my lord.
Okay, fine. Mr. Ihtizaz Ahsan.
associate, basically, he was amicus in this case before.
Bhai, please answer the question. Don't make a speech. Yes, no.
He was appointed as a lawyer in this case later on in 2012. If you see
Yes, no.
No, sir, because Mr. Farooq Ashtaik has instructed him not to appear in the court after.
Yes, no.
No, sir. No, sorry, not as a amicus, but he was lawyer in the last. If you see the last order,
We have you asked you a long speech. Try to be brief. He doesn't want to come. Okay, fine. Now we're left with only two amicus then. One is Mr. Makhdoom Ali Khan, one is Mr. Ali Ahmad Kurd. And Tariq Mahmood Sahab is not well, you said. So we may also consider appointment of substitute amicus, and we'll take on suggestions on board. Just bear that in mind. Please continue reading. Please continue.
Meanwhile, let the original record of the trial of Zulfikar Ali Bhutto's case be requisitioned from the Lahore High Court, enabling the learned counsel for the referring authority to obtain copies of the same if need be. For preparation of arguments, copies whereof shall also be supplied by him to all the above learned advocates. The office is directed to put up a note for constituting a larger bench.
Then the larger bench was constituted.
My lord.
Any significant order that we need to read?
My lord, there was one order.
One order I would like to
Oh, we'll come to you, Mr. Farooq. Naik, relax.
Okay.
My lord, there is this one order which related to, this is 3/5/2011.
3-5?
2011.
3-5, not 2-5.
3/5.
Ji.
My lord.
3-5 पढ़िए.
Ji. Dr. Babir Awal, learned senior ASC, has addressed arguments at a considerable length, making reference to a number of documents to assist the court for the purpose of answering the questions framed in the reference. The learned counsel has also
Attorney General, we just have 2nd of May, not 3rd.
3rd of May, sir.
हाँ नहीं तो इनका कसूर तो नहीं है.
No copy of order dated
3-5-2011.
Ji, my lord. There is a 2nd May, and after 2nd May it was adjourned to 3rd May, and then
We just don't have the order.
you don't have it.
2-5 है, but the main file I have. So what we need to do also is make copy of the entire order sheets.
नहीं वो है दूसरे फाइल हैं
आप दूसरे फाइल है कह रहे हैं.
ब्लू फाइल देखें
Different file है.
चलो इकट्ठा कर
चलिए पढ़ लेते हैं. Let's hear.
I'll read out slowly.
Yes, please
I'll read out slowly.
वो निकलवा लीजिए 3-5 वाला जजेस के लिए. आपको भी निकालना है. जी,
ये अब slowly मैं जरा पढ़ूंगा.
please read it.
Ji, the learned counsel has also moved an application, contents whereof are reproduced herein below, that the in charge of police station Ichra, Lahore, may be directed to produce the entire record along with register number 9 in respect of case against Mr. Zulfikar Ali Bhutto.
1 second, Mr. Attorney General, just a second. We've just found the order.
My lord.
There's a separate file with all the orders
Yes.
in it. So just a second.
Yes.
And
Ji.
32 पे जी you reading from the second पूरा ही पढ़ लेना Dr. Babar Rahman.
Ji, Dr. Babar Rahman, learned senior ASC, has addressed arguments at a considerable length, making reference to a number of documents to assist the court for the purpose of answering the questions framed in the reference. The learned counsel has also moved an application, contents whereof are reproduced herein below. That the in-charge police station Ichra, Lahore, may be directed to produce the entire record along with register number 9 in respect of case against Mr. Zulfikar Bhutto, former Prime Minister of Pakistan, in order to establish that the case was consigned after due investigation and on whose directions the same was reopened. 2. That the above request is made in the interest of justice. Next para. We consider that the production of the aforesaid record is just and proper during the hearing of the case. Therefore, the learned Advocate General Punjab is directed to procure the same in safe custody and produce it before the registrar, which will be examined in accordance with law. I can skip the next para. Qazi Muhammad Ashraf, learned senior advocate, has joined the proceedings as amicus. The office is directed to facilitate him. And
When is Mr. Qazi Ashraf present?
He's not present today.
So he was another amicus.
Yes, my lord. And he appeared also a few times before this.
He's well?
He's well. I met him yesterday in the High Court.
And?
He's okay. He's well. He's hard of hearing. He's hard of hearing a little bit.
प्रैक्टिस कर रहे हैं इतना
जी प्रैक्टिस कर रहे हैं मगर उनके अब जरा क्या कहते हैं थोड़े से
कराची वाले काजी अशरफ?
कराची वाले काजी
Okay, I know.
कराची वाले
ठीक, ठीक.
Ji,
Any other order you would like?
next following order, because this was
let's read
the
it.
record of the police station.
4th May.
4th May. Dr. Babar Rahman, learned senior ASC, has addressed arguments and reads out various documents of legal order sheets of the High Court. 2. Khwaja Haris Ahmed, learned Advocate General Punjab, stated that the record of investigation of FIR number 402/1974, initially conducted wherein the case was consigned on 1/10/1974, being untraced, has not been made available. However, it is pointed to him that normally 4 copies of the police record are prepared. Therefore, further efforts should be made to locate the relevant record. 3. Secretary, Ministry of Law has produced copies of certain notifications that be placed on record. Now, the next order, 5/5/2011. Dr. Babar Rahman, learned senior ASC, continued arguments in support of his contention, during the course whereof he prominently made reference to the proceedings conducted after the dismissal of the review petition until the execution of sentence of death awarded to Mr. Zulfikar Bhutto. Second para. In the meanwhile, Khwaja Haris Ahmed, learned Advocate General Punjab, has been called upon to explain as to whether the original record of FIR number 402/1974 registered at police station Ichra, Lahore, has been traced or not. As already observed, we consider it prima facie essential to understand the case from the record maintained by the police up till 1st September 1975, when reportedly it was consigned to record as untraced. But subsequent thereto, on the basis of some inquiry, which was entrusted to P.W. Abdul Ahad in respect of conduct of FSF personnel, investigation was started, during the course whereof investigation of FIR number 402/1974 was revived. And in the meanwhile, Masood Mahmood and others started making incriminating statements, etc. in the case. He has explained that in spite of best efforts, record has not so far been made available. However, on being asked, he read out the contents of paragraph 8 of the judgment of the Lahore High Court, reported as PLD 1978, Lahore 523, as well as the
So
relevant...
the record was found or not found?
My lord, this original...
Rather than reading all these orders, just tell us in a nutshell, was it ever found or it's still untraced?
So this is, my lord, the original record from the police could not be found.
Untraced.
Ji.
Okay. So why read the rest of the order? Anything significant?
इसमें ये हुआ कि इसमें जो उसकी जो कॉपीज थी
जी सर मैं बताइए अच्छा का रिकॉर्ड आ गया हुआ है
नहीं वो जो आया है वो FIA की जो केस डायरीज थी वहां से आ गया वहां से आ गया
तो 3 बंडल्स हैं उसके 3 बंडल जो पुलिस के 3 बंडल
Okay, okay.
जी जी
Is it recorded?
The file number 6, 7 and 21.
पुलिस की 3 फाइल आई हुई हैं. चलिए ठीक है. So
6,
why are you
7 and
telling us all
21?
this then?
But we need not need.
No, tell us some relevant stuff.
My lord, after this, there were The arguments, so the only thing which was left perhaps was the record of the complaint, if I gathered it correctly.
Mr. Attorney General, I just have a question. Before we come to the question of law under 186 and legal maintainability argument, as a matter of fact, could you tell us when the judgment was passed? Was the Constitution in abeyance at the time?
When the judgment was passed, yes, the Constitution.
At that time, could you give us a little background at that time? What was the political dispensation like at that time?
My lord.
When was in abeyance? Were there any appointments made during that period? That period needs to be understood when the judgment. No, 79. Either the trial period, maybe the whole thing. When it started, what was the political situation? Was the Constitution in abeyance at that time? Was there a constitutional deviation at that moment when this entire process took place?
My lord.
As a matter of fact, we still come to the question of maintainability, which is very important, we should have to answer. But as a matter of facts,
my lord,
maybe you want to put it together.
Ji. My lord, on the night of 4th and 5th July 1977,
we would like to see the notification, everything you see in front of us, part of the record.
ये नोट कर लीजिए, बाद में you can provide them later. Please continue.
Another order. So there is another order I was requesting.
Please, which is the other one? Just tell us or you can read it, which is the relevant ones, orders that read them.
My lord. This is an order dated 12th May.
12th May of which year?
2011.
You see, the precise question is, I'll rephrase it again for the Attorney General, maybe you want to put a file or a paper book on, that the entire trial going up to the Supreme Court was during a period when Constitution was in place, or was it not the case?
Yes.
Was there any constitutional deviation during this period when this entire case took place? That's all I want to know.
Yes. So the country was under martial law.
So if your lordship would allow me,
I think we can take judicial notice of the fact that
the country was under martial law up
No,
until
but I just want the dates and,
but be precise. That's what my brother is saying. 12th May you wanted to read.
Order dated 12th May 2011. May I read, my lords?
12th May?
49.
12th May. From the perusal of record, it has transpired that after imposition of martial law on 5th July 1977, the criminal case against late Zulfikar Ali Bhutto, which stood consigned, was revived. It appears that in the meanwhile, a private complaint was also filed on behalf of the family members of late Nawaz Muhammad Ahmad Khan Kasuri, which initially remained pending on the file of an additional session judge at Lahore. And perhaps in the month of August 1977, the same was transferred to the file of the Lahore High Court. The record so far received from the Lahore High Court through its registrar does not indicate that the record of this complaint has been transmitted. Therefore, the office is directed to requisition the same by sending a letter to the registrar, Lahore High Court, with direction to procure it and forward the same to this court. 2.
Why you read this?
Because this complaint has not come.
Which complaint?
Which has been mentioned.
The record of complaint has
record of the complaint has not come. Now I'll read para 2 also.
A complaint regarding what?
See, complaint was filed.
Private complaint.
Private complaint.
So there was a private complaint also, which was
the
filed.
significance.
Because that would show it was an afterthought what was going on. Because
paragraph 2,
private complaint.
Paragraph 2 अगर इजाजत हो पढ़ें clear हो जाएगा.
Okay.
Additionally, 5 different cases, probably under various provisions of the martial law regulations, were also registered against late Zulfikar Ali Bhutto. During the hearing of the criminal case before the 5-member bench of the Lahore High Court, and their hearing commenced at Court Lakhpat Jail from 2nd Feb 1978 by the tribunal headed by Mr. Justice Shafiur Rahman. The Registrar Lahore High Court is directed to procure the complete record of the said cases as well as transmit the same to the court. Sir, this is very important. It was a classified document, but it was declassified by the previous government. And this...
What is this tribunal headed by Justice Shafiur Rahman?
See, a tribunal was formed to look into the veracity of the FIRs, which were registered against late Zulfikar Ali Bhutto. And the tribunal came to the...
Sorry, I'm pursuant to an order. What was it? How did it happen?
See, an order was passed by the government. A tribunal was formed. And as a consequence whereof, the tribunal formed the opinion and given the verdict that all cases were fake and they exonerated.
Where is that way?
That tribunal, it is still not here. We have got to.
No. Take him, Mr. Please. Please, let's, I'm just asking, can you?
8 days को आपको private complaint जो है, वो that was filed on 31st of July 1977. Complaint was filed and it was transferred.
Where is the record of the tribunal?
It was transferred to the High Court on 30th of September 1977. These are 2 dates.
Where is the record of the tribunal?
This is it was ordered by this honorable
Mr.
court.
Farooq Naik.
Ji, sir.
Please hear me carefully. If you never want this case heard, you can raise these objections. We will go by what is available before us. If something is not before us and you just make a statement, this happened or that happened, if there is some document before us, if you want some document sent for, then you have to be very specific. We will not accept a statement unless that happens. Otherwise, this will just delay the matter. I mean, it's been fixed after a very long time, and if it's not there, it's not there. So if you know how to access it, please tell us. We'll pass the requisite directions to order the production of it. So don't say this is not here, this is not here.
No, my lord, if your lordship allow me, it is written in the order. The Registrar Lahore High Court is directed. He is directed to procure the complete record.
What happened that I'm asking?
Nothing was written to them. I think so. This is what I've not seen any document.
We'll find out.
See, the registrar has to be written to bring the document on the record.
Many years have passed.
Yes.
Now, please, anything else you want to refer to?
And para 3 also, my lord.
Yes, read it.
It is important to note that 3 cases were registered.
These cases
were registered during the pendency of the trial of the murder case by the 5-member bench of the Lahore High Court. Therefore, we consider it appropriate to look into this record as well, because it is directed to procure copy of the order passed by the martial authorities under MLR 12 of 1977, along with copies of...
I must stop you now. If you want something specific sent for, please submit an application or give us particulars, this, and who can we direct to send it for? We'll pass such an order.
I'll do it, my lord.
If it is not available, we can't do anything about it.
Your lordship is right. I'll move a proper CM listing the documents which I want to be...
Not only that, just don't say I want this document. You have to say where
they're lying.
Where would it be?
Definitely, I've got to show where they're lying.
One second. Now, anything else in the order that you want to read out?
My lord, just one point, just by way of information. The report, Justice Shafiur Rahman Tribunal report, was the government at that time, both the federal and provincial governments at that time had decided to make them public in 2011 during the course of proceedings of this reference.
So if it's public, then we'll have it?
Yes.
Somewhere or the other?
Gigi, it is duly recorded in paragraph 7 of the order which my learned friend was reading out. Now, the only thing which is not available is the complaint, the record of complaint.
We've understood. Anything further?
That's all.
Okay. Anything you want to say? No, now I'll just say let me just consult.
Okay.
अटॉर्नी जनरल साहब, ये कंप्लेंट जो आप कह रहे हैं बार-बार प्राइवेट कंप्लेंट, इसमें तलबी हो गई थी मुलज़म की?
एक तलबी हुई थी, ये पहले सेशंस में हुई थी, वहां से फिर ये हाई कोर्ट आ गई थी. And there was a 2-member bench of the High Court headed by Mr. Justice K.M.A. Samdani at that time, who was seized of the matter on private complaint. अच्छा, जब ये private complaint at one end चल रही थी, तो नीचे जब ट्रायल स्टार्ट हुआ, तो ट्रायल जो है वो हाई कोर्ट ने अंडर 526 अपने पास मंगवा लिया. तो उस वक्त फिर चीफ जस्टिस ने 13 सितंबर 1977 को ये ऑर्डर किया कि ये अब यहाँ चलेगा. सो वो ट्रायल तो उधर चला, फिर वो प्राइवेट कंप्लेंट का पता नहीं लगा कि क्या हुआ वो 2-member bench.
ट्रायल के साथ प्राइवेट कंप्लेंट नहीं चली, ट्रायल के साथ मर्ज नहीं हुई एफआईआर एंड प्राइवेट कंप्लेंट.
I have not seen it from the record.
सुनवाई केस के तहत तो फिर कंप्लेंट पे पहले कार्रवाई होनी चाहिए
जी. वो फिर वो रिकॉर्ड में नहीं नजर आ रहा कि
किसी ने ऑब्जेक्शन किया डिफेंस साइड से, किसी ने कहा कि वो कंप्लेंट भी पड़ी है, इसको इकट्ठा रखे और उसको लगाएं पहले.
सर, जब एविडेंस पढ़ेंगे तो पता चल जाएगा उसमें objections दिए गए हैं.
Mr. Attorney General,
Then we read the evidence.
Farooq Naik
जी
sir,
sir, जी sir.
just to get the course right of
जी,
this
sir.
matter, I think the first question you have to answer is the maintainability of this review, and we'll come to the facts later of the reference. So you'll have to assist us that under 186, what's the question of law? Because a decision has been given by the Supreme Court, review has also been dismissed. Now, that is the end of the matter. On what principle? आपके जो grounds अभी तक आपने दिखाए हमें, they are talking about as if you are vesting us, your argument is as if Article 186 vests another appellate jurisdiction to review the existing judgments of this court. And all the grounds that so far that we've seen are factual relating to the judgment itself. Now the question is, there is finality attached to the decisions of the court, right or wrong. There could be bad decisions passed by the court, they're final. So the question is, what is the question of law that is for us to give our opinion on when the matter has already been settled by the Supreme Court? So if there is a question, you'll have to articulate. Is it outside the judgment, or because the factual position of the judgment cannot be touched? That's been decided. Review dismissed. That's the end of the matter. And we have no jurisdiction to review second review or look at it through a second appeal. There is no such concept under 186. So 186 at best would be a question of law which you will have to articulate before us. It cannot arise out of the factual position of the judgment because that's settled. We can't look at the facts. You'll have to go outside if at all there is any argument, which I don't see in the ground so far. So that's a difficult question. We already have decisions of this court and of the jurisdiction from India also, which say we can't touch a judgment given by this court and look at it at a policy level. If this happens, then tomorrow there could be references, we keep opening all our judgments. So you'll have to really articulate a point, under what basis do we go into 186, which I would imagine is a difficult one. So please concentrate on the maintainability and the constitutional question, how do we open this matter, if at all, how?
Your Lordship is right. See, under Article 186 of the Constitution, 3 tests have to be met before an opinion is given. It should be of public importance and question of law is involved. And if these 2 tests are met, then the 3rd test is with regard to giving an opinion by this Honorable Court.
Mr. Naik, the 186 says that the question of law is for the court to determine.
Yes.
The question of public importance is for the President to determine. That's for the President. We don't. That's not our problem. Our problem is, what's the question of law? Is the question of law saying this judgment is wrong? Is that a question of law? That is not, to my mind, frankly, speaking for myself, does not constitute a question of law that the judgment is wrong. There has to be more than that, and you'll have to come up with that argument as to what it is. Because if this is the policy, then tomorrow the President can start sending references and start revisiting all the judgments that we've ever given. That will not be a correct way of going about it, and you understand that.
I understand what.
So we'll have to come up with, you'll have to come up with something to tell us. What is that novel argument that shows that 186 can be invoked in this matter? So please, this is not easy.
To decide anything, we have to give the opinion.
Yes, my lord.
Therefore, what has been said till now, that relates to the determination of something by this court. That is not the scope.
It's actually a very serious question. Because when you say it's a question of law, the law has been decided in the judgment. Whatever judgment Supreme Court gives is the law of the land. So this is the law. So what's the question of law? So you can't say this judgment is wrong. It's not a question of law. There has to be something else.
Basically, the entire reference is based on the interview of the judge. Naseem Hussain Shah. That can be a question of law because it was a factual aspect that has been interviewed by some TV reporter after his retirement. And whether this can be a question of law because the entire reference, the crux of the reference is based on that interview. You have to address that, whether it will be converted into a question of law, whatever he has said. Because there were 3 dissenting judges also. He could have been a dissenting judge of that.
My lord.
What was the pressure on him? Why is...
Mr. Naik, let me take you to the real, what you think your question is. Your question is that during a deviation period or any dictatorship, the judiciary is not independent and they don't decide independently. That's a big assumption that you're throwing at us. You're saying that in any martial law, the judiciary is not independent. Hence, this is not a fair trial. You'll have to build a very strong case that how do you break...
औसतन 3,000 रुपए के करीब है, वो 4,500, 5,000, 5,000 से भी ज़ायद भी इस तरह की इतलात भी आ रही थी। तो वज़ीर आज़म साहब ने इसका नोटिस लिया, कल एक अहम मीटिंग भी थी। उस सिलसिले में क्या इक़दामात किए जा रहे हैं, वजूहात क्या हैं, उसके लिए हम आपके पास मुख्तसर इस प्रेस कॉन्फ्रेंस के हाज़िर हुए। सरफराज भुट्टी साहब भी मौजूद हैं और मोहम्मद अली जो पावर के जो मिनिस्टर हैं वो भी तशरीफ़ रखते हैं। जी भुट्टी साहब।
बिस्मिल्लाहिर्रहमानिर्रहीम। आप